investigates, he prepares, he goes back in on motions for the trial, he goes to the Court of Appeals, he goes to the Supreme Court. Scott Key, in his 15 years of practice up to this point, has won over 70 appeals. When the justices want to get an unbiased opinion about an issue that is being argued to them by the state and the defense bar, they call on Scott Key. He is a tremendous lawyer. He's a great human being. He's a husband and a father, and he is our final speaker for the day. Scott.
Well, Jason may be a little excessive. I appreciate the opportunity to come here and talk to you about a topic that really the law can't easily keep up with, and that is emerging trends in technology and how we take a document that is several hundred years old and the Fourth Amendment, and how we sort of translate that, or the Fifth Amendment, and we translate that into technology that literally is obsolete by the time that the case comes out. I want to talk to you about essentially cell phone searches, the Fourth Amendment and Fifth Amendment as they apply to technology, particularly cell phones, tablets, computers. For the folks who are watching remotely, I know that the brochure said that there's no way to take remote questions. If you will tweet any question that you have to me at JScottKey, #KeyCaseLaw, I will try to answer your question today at the end of my talk during the Q&A period. And if I can't get to it today, I will certainly go back and review your tweets with that hashtag and try to answer your questions at 140 characters if possible. And if it requires a longer answer, I'll try to give you a call. If you need to reach me any other way, I'm on Twitter at these two places, JScottKey and Miller and Key Law. We're on Instagram at Miller and Key Law and Scott Key. And if you want to give me a ring or email me, that's my contact information. You don't have to furiously scribble this down. The PowerPoint has been uploaded to the materials, I think, about an hour or so ago. So all of my contact information is there if you want to reach out to me. If you want to join the 5 or 6 people that read my blog, that's a blog that I update sometimes every day, sometimes every 6 months or so. So that's my blog, GeorgiaCriminalAppellateLawBlog.com. I'm going to talk to you about 3 specific topics today. And one is going to be Fourth Amendment and cell phone searches. The second is going to be Fifth Amendment and how it relates to orders to decrypt, like court orders to decrypt hard drives, court orders to provide us with your passcode. Give us your password to get onto your computer. Give us your passcode to get onto your phone. And then we're going to talk about subpoenas and search warrants for subscriber information. And this is cell phone location data and things like that. One admonition I would give you is look at the cases that we're going to discuss more as case studies. I mean, it's good law, it's precedent, but more as case studies than as case law. I mean, honestly, in the time that it takes from a case to go from a person has been arrested to they've gone on trial, the suppression hearing has been held, they've been convicted, the case has gotten up to the Georgia Court of Appeals or Georgia Supreme Court, or it's gotten to the 11th Circuit, or some of the bigger cases, particularly by the time they can get to the U.S. Supreme Court. That's a 3 to 5 year journey, if not a little bit longer. A lot of the stuff that we're going to talk about today, or you've heard about through the course of this seminar, if a case takes 5 years, say, to reach the U.S. Supreme Court, 5 years ago, Snapchat didn't exist. 5 years ago, I don't think Instagram existed. Facebook existed 5 years ago, but not in its present form. So by the time the precedent comes out, probably the precedent is interpreting some set of facts that may not be that set of facts anymore. And so anytime that you're in this area by analogy. So you are, and you have, if you look at it, a lot of these cases talk about, well, what is a cell phone? Is it more like this thing, or is it more like this thing over here? That is just a long way of saying, when it comes to understanding the issues that might arise in a case, appellate issues, issues that you need your judge to rule on, issues of fact for a jury, please don't be a dinosaur. The law moves slower than the technology does. And you know, when I first started practicing law, you know, the joke that we had in the office where I worked was Waffle House is in every case, right? Every trial transcript I would ever pick up, somebody was at Waffle House. Like, you know, either like they left the Waffle House and then they got the DUI, or the drug deal was consummated in the parking lot of the Waffle House, or the dead body was in the trunk of the car and they stopped and they went to Waffle House before they went and buried it. Like Waffle House was every case in like 01, 02. I don't see Waffle House in as many transcripts as I used to, because I believe that the technology, the smartphone, Facebook, Instagram, Snapchat, Kik, you name it, like the telephone, the social media is like the Waffle House of the modern criminal case. And so, you know, understand that these things aren't getting done at Waffle House anymore; they're getting done on the phone. And so, not knowing what these social media outlets are is sort of like in 01 not knowing what the Waffle House is. Why is everyone eating breakfast? And you know, you just need to know. And if you don't, you need to probably try to get on some of these social media networks, even if you don't do a thing on them, even if you never post a single thing on them. You probably need to be on them to know what they are, because it's going to come up in the context of the case. And if you don't know, and you have like a 15-year-old child, or 14-year-old child, or like a niece or a nephew, go and ask them. They will give you a tutorial. I talked to my daughter all the way to school about exactly what Snapchat is the other day, and she probably should be here speaking instead of me, because she knew what she was talking about. Understand that if you don't, and I read so many transcripts where a lawyer is cross-examining and something was on Facebook, or something was shared on LimeWire, or something was on Twitter, or something, you know, just where the lawyer is asking questions in such a way on the transcript where I just want to put my pen through my eyeball, because the lawyer doesn't know what the hell he's talking about. And I have seen it have some devastating consequences. If I'm reading your transcript, it didn't go well. And probably the reason why I'm reading your transcript is because the lawyer didn't get it. So understand that if you miss these issues, if you don't understand what in the world is going on, you're probably going to nuke your client's appeal, you're probably going to miss a legal issue, you're probably going to sound incredibly dumb in front of a jury. Okay? The ADA is going to be generally a little bit younger. The ADA is going to get this. The ADA can call like Joe Caselaw from the GBI to come and explain all of this. The DA is going to get it. The AUSA is going to get it on your federal case, and you don't want to, and like most of your juries are going to understand. You don't want to be the dumbest guy in the room about this information. So, how well do you need to know it? I think you need to know, not only do you need to know the technology, but you need to know it well enough to teach it to judges and justices who don't quite get it yet, okay? Because your judge may not understand what this stuff is, and you may need to be able to package it and explain it to a judge. There are I can think of two, like a judge and a justice who totally gets it. Look at Judge Dillard opinions. Steve Dillard on the Court of Appeals. He's on Twitter. I mean, he's a madman on Twitter. He is all over Facebook. Judge Dillard sort of gets it. And then Justice Don Willett on the Supreme Court of Texas is another justice on Twitter, and he's all over it. These guys write really good opinions. And honestly, if you want to understand how to write briefs and how to talk about technology in legal writing, go right now after this talk and read New versus State, 327 Georgia Appeals 87. This is a Judge Dillard written opinion. It's heavily footnoted. Every time, like the word cash, C-A-C-H-E, not like Johnny Cash. And every time like cash or deleted files or, you know, an IP address. Every time something, like some computer or technological term, like arises in the case, Judge Dillard drops a footnote and explains it. It is a very well-written opinion. I don't agree with the holding in the opinion, but it's a very well-written opinion in terms of if you want to look at how to write in a smart way about technology, take a look at the new decision. And basically, the precedent of the new decision is important to talk about as well. New involved a person who was coming through the airport. He had a computer, and he was suspected of possessing child pornography. When the hard drive was submitted to forensics, there were some images that were found on the computer that had been deleted, right? And some of you may be like, well, come again, what do you mean? How do they find people deleted? When you delete files, they don't like just disappear. Like they go live in some other place on your hard drive, and there was some child pornography that had gone to live in another place on the hard drive. And the question was whether or not there was sufficient evidence under the Jackson versus Virginia standard on whether or not he was in knowing possession of the child pornography that was contained in the deleted files. And the new decision holds that there was at least a jury question. It is entirely possible that the guy put the contraband over there, sort of like a false compartment in a vehicle, to like later extract it to use for whatever people use that for. And so there was a question of fact for a jury as to whether or not, in spite of the fact he deleted the information, whether or not he was in knowing possession of it. So, but new is good for that precedent. It's also good to just look at a very well-written opinion, and you could write briefs that sort of track the same style of the new opinion. So not every judge is like Judge Dillard. Not every justice is like Justice Willett out in Texas. In fact, you know, I think you are going to have to, when know your particular judge really well, but when you write a legal brief or when you prepare for an oral argument, you know, unless you know this is a very knowledgeable, Judge Emerson out in Douglas is actually pretty good on the tech. Unless you know it's a judge that's savvy on technology, pretend that the judge that you're going to be in front of is like that crazy uncle that comes to Thanksgiving, that always wants to hand you the computer or his phone to like figure out what the hell's wrong with it. Like, just imagine that that's your judge and you need to figure out how to get these concepts across, which means you have to know these concepts. So, new versus the state. I want to talk about the first topic, which is Fourth Amendment and cell phones. And in terms, and we're going to talk mainly about a case called Riley, the Riley case, Riley versus California. And Riley really poses a question. What is a cell phone? Is a cell phone, is it like a phone? Is a cell phone a phone? Is it literally like just a modern version of the thing that some of you may remember that you used to dial? Is it like a phone? Or is it more like a warehouse that contains, you know, thousands upon thousands of files? What is a phone? And the answer to the question, what is a phone, you know, upon that question turns the answer to whether or not a phone can be searched, roadside, incident to a lawful arrest. And so this is sort of the big new case. It's a newer case about searches of cell phones. And it's Riley versus California. It's a 2014 case. It's 134 Supreme Court 2473. And let me give you, I feel like I'm in a law school. I should call on one of you to give me the facts. Yeah. Because I was at the old version of this law school, and I used to get really scared in rooms like these. And I think it's a lot scarier to sit there in rooms like these and over here in rooms like these. But I'll give you the facts in Riley, because you had to pay to come. Ryan, you had to pay to come to law school too. The facts in Riley are these. David Riley was in a car that was stopped. The San Diego Police Department found firearms stashed in a sock under the hood of Mr. Riley's car. Right? I mean, your day's about to get bad when the firearm that you stored in a sock under the hood of your car is discovered. But it gets worse. Mr. Riley is arrested and he's searched incident to that arrest. You know, that's the sort of thing that happens every day. And then during the course of that search incident to arrest, police find some evidence in the car associating him with the Blood Street gang. I don't recall what it was, maybe it was the red handkerchief or something. I don't know what it was, but they found some items, incident to that arrest associating Mr. Riley with the Blood Street gang. So his day got, Mr. Riley's day gets worse, right? Then the police grab Mr. Riley's smartphone without a warrant, which they think they can do incident to arrest because you're arresting him. He's got his cell phone in his hand. And then they open the phone and they start going through it. And when they go through the phone, they find evidence that further connects him to the Bloods gang, as well as evidence placing him at the location where someone was shot about 3 weeks earlier. There's a motion to suppress the items found on the cell phone. The judge does what trial courts do best and denied the motion to suppress. And then they took it to the California Supreme Court, where, like in about a page-long opinion, the Supreme Court of California, and he's convicted of assault with a semi-automatic weapon, shooting into an unoccupied vehicle, and attempted murder. And the attempted murder, the shooting into the unoccupied vehicle, that's all developed as a result of the search of the cell phone. The California Supreme Court holds it was perfectly okay to grab that phone from Mr. Riley, to search the contents of the phone, because he was arrested. It was a lawful arrest. They were able to get that phone because the phone is more like it's a phone, not a warehouse. So the California Supreme Court says no big deal. You can seize it. It's a phone. You can look on it. You can inspect it. Like it's not a warehouse. It's a phone. And pretty short order. There's a companion case.
That happens every now and then. It'll come like that.
I know, right? I'm just lecturing everybody about this, and look at me. Okay, so there's a companion case in Raleigh, and that is Breema Worry. W-U-R-I-E is the companion case. Breema Worry is arrested shortly after consummating a drug deal outside, and I just got to tell you the name of the convenience store because I just love it. It's Little Peach. He's Lil, L-I-L, outside the Little Peach convenience store. Police take the cell phone. They observe that he has some missed calls from, quote, my house. The officer, and this is a flip phone. This is a dumb phone. This is kind of an older, this is a little bit older fact. It's a flip phone, and they jot down the number to the contact my house. Officers track down that number to an apartment where they find what is this is a quote from the case, the quote hidden mother cache, including guns, drugs, and cash. So apparently, like they go to this guy's like wonderland of contraband, and they find a bunch of stuff, and he's prosecuted federally. He files a motion to suppress. You wouldn't have found this stuff at my house had you not flipped open the phone and looked and found out what this number was, and then tracked it to the house. The district court, that's what district courts do best, denies the motion to suppress. The case goes up to the First Circuit, and the First Circuit does what the 11th Circuit doesn't do and reverses the district court. And they hold that the phone is like a warehouse. It's not, even the dumb phone is more like a warehouse. It's not like a phone. Both of these cases go up to the U.S. Supreme Court. On appeal, the government really, they proposed that this should be handled in one of two different ways. One would be just to follow the Arizona v. Gantt methodology, and that is a warrantless search of the contents of the phone should be permitted if there's reason to believe that the phone contains evidence of the crime for which he's being arrested. So in other words, if there's reason to believe that whatever you're being arrested for, there would be evidence of that thing on the phone, it's no big deal. Under Arizona versus Gantt, you ought to be able to go onto the phone and find it. Or they suggest if you don't like that, Supreme Court, maybe the analog test, which is a warrantless search is permissible if law enforcement could have obtained the same information contained on the cell phone from some pre-digital counterpart to the contents of the phone. So in other words, if the guy had his like address book and calendar, it wouldn't be a big deal to flip through that. So you really shouldn't be a big deal to flip through the phone as well. You know, the trouble with that is these exceptions would quickly swallow the rule, because there's nothing that I can imagine that you could be arrested for, even if it was a DUI, right? Even if you were getting arrested for a DUI, probably if you are arresting a 20-year-old kid, there's some reason to believe that there's probably like a bunch of guys doing shots like in the photos, right? So this would quickly swallow the rule. What the Supreme Court does is they apply a balancing test, which is you have to balance the government's interest in doing an immediate search versus the privacy interest of the individual. So let's talk about the government side of the scale first. The government's position was, or the Supreme Court held, that really what you're, in an Arizona v. Gantt type of a situation, in a search incident to arrest of an automobile, the whole purpose of a search incident to arrest is to protect officer safety, and that's why it was admitted to begin with, which was, if the guy has a handgun in his pocket, or a handgun within arm's reach, or arguably a handgun somewhere within the vehicle, you should be able to search for that and not have to wait and get shot while the cop is going to find a warrant. So, the one risk that the government was worried about was officer safety, and the second was risk of an erasure. If the guy's got the cell phone in his hand, he can conceivably start erasing things, or if he keeps the cell phone switched on, there's a chance that one of his associates could remotely wipe the contents of the phone. On the Find My iPhone thing, those of you that are aware of that, like if you lose your phone, there's an app that you can flip your laptop open, and if you find where your phone is, you can remotely wipe the contents of the phone. There was a concern that the phone would be remotely wiped. You have to weigh those, the risk of the exigent circumstance, officer safety or loss of evidence, versus the privacy interest of the individual. And the privacy interest of the individual for the Supreme Court are pretty vast. There's a vast amount of data that can be stored on a phone. I bought the 7 Plus. I'm that person that stays up to 3 o'clock in the morning to order the new iPhone the minute you can get it. So I've got the 7 Plus. It came on the day that they all ship, and I have a cell phone that, I have a laptop computer that I start getting this little flag that comes up that says you're about to run out of storage. Okay, my cell phone right now has more storage on it than my laptop that I bought 3 years ago does. So if a cop pulls my cell phone out of my hand, there's arguably way more on that cell phone than can be on my computer. So a vast amount of data can be stored on the phone. It's more like the warehouse than it is the telephone. Not only the amount of storage in the telephone, but just the idea of what we use phones for these days. Our whole lives are there. Our medical information is on there. Our banking records are on there. Our most private things, we walk around and it's on our phone. So in terms of this balance, the Supreme Court said, essentially, if you want to search a cell phone incident to arrest, you have to go and get a warrant. Because unless it is just a true exigent circumstance, and those would be pretty rare. What I could imagine, and if you listen to the oral argument from the Riley case, this would be the situation like the guy with the cell phone, is a terrorist, and there's a time bomb ticking away. It's like an episode of 24 or something. There's a time bomb, and the code to defuse the time bomb, the cop knows is inside the telephone. Okay, that's a true exigent circumstance. But the possibility that this guy's associate might be coming to kill somebody, it's a little remote. And the risk of erasure, you could just switch the phone off, right? That's all you have to do, is just switch the phone off. Searching the telephone won't prevent things from getting erased. In fact, if the cop on the side of the road is trying to figure out how to get into the guy's phone and trying to search through it, he's actually keeping the phone powered up for the period of time he's doing that search, and actually is increasing the risk of erasure. So the takeaway from Riley is, Searches of the contents of a cell phone require a warrant unless there truly is an exigent circumstance. That balance is just about always going to tip in favor of privacy. And I think the most important thing about Riley is you need to keep the framework, the analysis in Riley in mind when you have cases that come up that aren't exactly on point but are similar. I think if someone pulls an iPad or someone guns in and takes a computer from a residence, and I think you're probably going to see fewer and fewer computer cases. I think probably it's all going to be on the phone. Just about being, I don't know that people are really, the computer's kind of going away, and I think most of the action is going to be on tablets and smartphones. But keep that balancing test in mind. It's, you weigh in terms of whether you should get a warrant or not in an exigent circumstance situation, you weigh the government's interest, which is exigency, officer safety, risk of erasure, against privacy concerns, which would be, and you would want to argue if it's the sort of thing where you might expect intimate details about a person's life, if it's something where you might expect a vast amount of data, then there's no reason why you can't go and get a warrant before you look at that. And it's not like warrants are hard to get. And I suppose you could put the phone in a Faraday bag, which is a bag that would, prevent any incoming or outgoing transmission. So that's Riley. I have a case that's on a petition for cert. It's called Campbell, Pinata Campbell versus the state, where I lost on a Riley issue, and I also lost on an ineffective assistance of counsel for the way the lawyer handled the Facebook issue, like just sort of what I was talking about earlier in my talk. So take a look at Riley. Riley's fairly new in terms of precedent, and it remains to be seen whether the balancing test from Riley is going to be just for that narrow roadside search of a cell phone, or whether or not that balancing test is going to be applied into other areas that come up with technology. And I would try to apply that balancing test in every sort of analog circumstance you can, because I think it's one of the rare, frameworks for decision that's actually beneficial to us.
Scott, what's the site on the Campbell case?
Oh, Campbell, I can get you that. Well, I think, you know what, the Campbell case is in the materials. And my briefing from Campbell is in the materials.
Is it 2016 case?
2015, I think. It could be 2016. It's on cert now, but the materials, the opinion and my briefing for it are all in the materials.
Oh, awesome.
Mm-hmm. Okay. All right. So the next thing, that was Fourth Amendment. The next topic is orders to decrypt computers. Orders to in other words, give me your password. Give me your passcode to get me into your computer. Now, a lot of you probably followed the Apple case, over the summer. Apple's a little different. Apple actually deals with directing a third party to unlock somebody else's phone. And we'll get into that a little bit in a minute. But what I'm talking about is the police now have your phone. The police now have your computer. They have a search warrant. Their tech people have not been able to decrypt the hard drive. Their tech people have not been able to bust through your phone, which, by the way, is kind of frequent. I mean, forensics can't get to that stuff like more often than you would think they can't get to that stuff. And so what happens if you get a court order to, like your client gets subpoenaed to the grand jury, and the subpoena says, decrypt your hard drive and bring us the decrypted information, or give us the passcode to get into your telephone. The 11th Circuit case on this is U.S. v. Doe. People named Doe tend to get in trouble a lot. So U.S. v. Doe, also Henry grand jury subpoena, 570 F3rd 1335. The opinions in the materials, 2012. And really, again, we go to analogy again. What is the act of providing a passcode like? Just like the question for the search of a cell phone is it more like a phone or is it more like a warehouse? The question of when the government or when a court orders you to produce a password or to decrypt files, is it more like you're being asked to bring a stack of documents to the court, or is it more like you're being asked to say something? Is it more like you're being asked to testify? What exactly is going on in a situation like that? So the Doe decision. These are the facts for Doe. The police begin investigating Mr. Doe's YouTube activity, and he's been sharing some contraband via his YouTube account, some child pornography, and they trace the IP address that's linked to the YouTube account, and every time they trace it, it's to some hotel. It's to some hotel Wi-Fi. They finally trace it to an IP address where Mr. Doe is staying, and so they arrest. I don't think they arrest Mr. Doe because they don't exactly know that he's doing it, but they do seize. They get a search warrant and they seize the computer equipment contained in the hotel. They get the computer equipment, but the FBI computer forensics people cannot decrypt the hard drive. They can't get onto it. So Mr. Doe, who has not been charged with the crime, is subpoenaed to the grand jury, where he is ordered to decrypt the information on his computer and bring the decrypted version of the hard drive to the grand jury. Mr. Doe doesn't want to do this, as you can imagine. And Mr. Doe says, and he advises the government, probably through counsel, that he is going to take the fifth. He's not going to do that. So the government then does what the government does in these situations, and they grant him limited immunity. They grant him immunity to what is contained on the hard drive, but they reserve the right to make derivative use of whatever they find to go and develop that in their own investigation. So in other words, they can't use the materials on the hard drive, but we can develop it in our investigation against you, and what we find as a result of that, we can use that against you. So Mr. Doe shows up, takes the fifth. He's held in civil contempt for the decision not to produce the decrypted information. The case goes to the 11th Circuit Court of Appeals. And the question is Mr. Doe being asked to produce information, or is he being asked to testify? And here's the analysis. The analysis turns on not on the contents of the information. The information turns on what the act is. What is Mr. Doe being requested to do? And is it testimonial? And the 11th Circuit answered yes. This is testimony. The decryption and production of the hard drives would require, quote, the contents of Mr. Doe's mind to do, not just the physical act. He's not being asked to unlock a safe. Like you have a key to the safe, or he's being asked to produce the contents of his mind in some way. He's actually doing something to decrypt the hard drive that is more like testimony than it is copying documents. And the government goes on to say, well, even if it is testimony, it's not incriminating because we've given you immunity. But the immunity is not full enough. It's not blanket immunity because they can derive whatever information they get from it to then develop their investigation against Mr. Doe. A, it's testimonial, and B, it would be incriminating because the government's going to get information to do something with. Now, you'll hear this terminology used a lot in these cases, which is the foregone conclusion exception. And the government argues that it's a foregone conclusion that we would have found this information, or we would have found what we're going to find here, which is, why would you need it then? The foregone conclusion exception doesn't apply because it's not like the government knows exactly what they're looking for. Like, it might be different if the government said, we want you to decrypt your hard drive because we know that these 5 documents are there. We want you to decrypt it and give us those 5 documents. If that was the case, it might be okay. But because we just want to see what's there and find out and discover for ourselves, the foregone conclusion exception doesn't apply. And I've yet to find one of these cases where the foregone conclusion exception does apply. Remember, the trick in these cases is that the question does not turn on the privacy interest or the contents of the hard drive of the device. That's really not even part of the question. The question turns on what is the person being requested to do. If he's being requested to do something that is like testifying, then the Fifth Amendment applies. So these are Fifth Amendment cases. These are not Fourth Amendment cases. And it's really easy to sort of get caught up in the yes.
Box.
Yes, sir.
He's going to get box.
Oh.
I've asked you to before.
So what about, we're moving away from passwords and moving fingerprint, retina scan. Does this fall apart?
So the question is, what about password? What about like fingerprints and retina scans? I mean, I think you have to make the argument that, and I think that's tougher. I mean, I think that's a tough case. I mean, I think the argument could be made that that's not testimony. The argument could be made that but I think because the information is tied to a body part, you just have to make the argument that it's more like testimony, although it doesn't seem as much like testimony. I think the production of the fingerprint for the purposes, well, honestly, let's think about this. If they get your fingerprint at book-in, when they book you in, they've got your fingerprint. I guess they can mold it onto something, and then they could use it to unlock your phone, and they don't need you to do a thing for that. So probably if they do that, and I think if they request you to produce your fingerprint for the purpose of the search warrant, like Mr. Doe might be okay because he wasn't arrested and he wasn't processed. But if they have his fingerprint on file for some previous arrest, they don't need Mr. Doe to do anything, so probably they can get it in the computer that way.
Do we not already have a case on fingerprints for biometric security?
We may. I mean, I'm sure there's a set of those around.
I figured you'd know, man.
But once they have your fingerprint, they don't need you to do anything. Yes.
Do you think it matters where the government got your print, for instance, people are printed to take bar, which is different than being printed to, because you got arrested?
Yeah, and I think you have to make that argument. I mean, I think that's sort of an open. See, you're already doing this. Like you're already turning the analogy toward the particular set of facts. So, the holding here is, and any order to decrypt contents of a hard drive is an order to compel testimony. Any immunity that leaves room is it leaves room for use of the information that can be used against you is a violation of the Fifth Amendment. The next case is SEC versus Wang, which is actually a securities fraud case. And the question in the SEC case, and again, the case is in the material, what if the holder of the password is an individual employee in possession of a company's cell phone? And again, here, remember the analysis. The focus is on the act, not the content. So the employee is requested to bring in a cell phone. He's requested to then unlock the cell phone. And the argument is it's not even your telephone. It's the company's telephone. So you don't have a right. The government's argument is you don't have a right to tell us you're not going to produce that because it's not even your phone. Again, it doesn't turn on what the contents are. It doesn't turn on what the equipment is. It turns on what you're being asked to do. And when he is asked to produce his password to the phone, it's testimonial. And so the court in the Eastern District of Pennsylvania says that he's not required to produce his cell phone. Okay, and that's just the holding in that again. So just keep that in mind. I think your analysis, whenever you're being asked to unlock something, you're being asked to decrypt something, you're being asked to do something, is that like testimony, or is that like being asked to go to your file room and bring us these files? If it's more like bring us these files, then probably your guy loses. If it's more like testimony, your guy wins. And there's a zillion sets of facts that we can envision that maybe the answer doesn't exist yet. This is the framework to analyze it. All right. Now, some questions ahead. Jason and I are actually working on a case together. where, and motions have not been heard on this case yet, where the guy's arrested, police can't get into the cell phone, but the guy's in jail, and the magistrate judge says, yeah, we'll let you out on bond, but a condition of your bond is you must provide the passcode to law enforcement so that they can get into your phone. So that case is a case that we have on motions right now. And, you know, we're gonna argue that that's testimonial. And that's more, and I think that's more in the line of a Jackson Beno Miranda type of a situation, which, and potentially a benefit. You get out of jail when you give us this information. What county is it?
That's Tift County.
Tift County. So, that, motions are on December the 15th.
For us, it's the county of hell.
So, that's really the second. And then, I'm gonna spend just a brief few minutes on
So
subscriber.
how do they not even, I'm sorry, how do they not even see that that is, here, how do they not even see that that would be an issue with hope or benefit? You know, how does opposing counsel not even understand that?
It's just Tift County. So we hope that comes out that way. But I have my spidey senses tell me that they're going to continue to not see it that way, even in you know Illinois and some of these other cases. But yeah, they just said you can get out. It's the same thing as those judges when you appear at arraignment and they go, hey, if you pass it, could you pass a drug test right now? I mean, like he hasn't been sentenced, but like you show up at arraignment and the judge asks your client to take a drug test. There are some counties where they do that too. So the next topic is subscriber information, cell phone location data. And I want to, and all three of these cases are in the materials. And this is US v. Graham, US v. Davis, which is an 11th Circuit case, and US v. Carpenter. This is basically, is a warrant required to get cell phone location data? Is a warrant required to get your subscriber information from the cell phone provider? And essentially, the answer is no. And that comes under what's called the third-party doctrine, which is any information that you would give to a third party. In other words, once you are using and this is really the holding in Graham and Davis. I think Graham, the issue was it had been like an armed robbery of some sort, and they had gotten the cell phone tower location data to put the guy's cell phone at the scene of the robbery. And I think they had even dug into some historic cell phone location data from earlier telephone calls. And the holding in Graham, Davis, and Carpenter is that anything that you, by virtue of your decision to use a cell phone, that you're allowing the cell phone provider to have, that the third party, Verizon, can know where you are. Because you use that cell phone, you couldn't use it without them knowing it. And you can't use a lot of the apps on the cell phone without being able to provide your location data. That's the reason why, like when you put a photo on social media, like someone can know where the location is. That's the reason why you're able. It's the reason why I was able to use my GPS to find Georgia State Law School. Once you provided that information to a third party, you've sort of waived some of your privacy in that, and so there's no need to get a warrant for that. Which, you know, the good news is I've been able to subpoena a lot of this stuff in my cases. So just keep in mind for the subscriber information and location data, that's pretty public and it doesn't come under the Fourth Amendment. In conclusion, cell phone searches almost always will require a warrant per ride, unless there's a true exigency, and that's literally like there's a bomb on the bridge and the cops know that the way to defuse that bomb is in that cell phone. A person will not be required to decrypt a hard drive or provide a passcode to his or her device without a grant of full immunity. That's US v. Doe and other cases like it. And then the government may freely get access to cell phone location data without a warrant. And that's Graham, Davis, and Carpenter. And the takeaway from this is stay current on technology and the law so that you can be creative in applying the Fourth Amendment, the Fifth Amendment, to issues as they arise. I can't anticipate, nor can you anticipate everything that might, because we don't know what the next thing is going, we don't know what the next Snapchat is. We don't know what this technology will even be like a year or two from now. But you have to sort of have this framework to apply, and you have to know, you have to understand it and be creative about it. And that'll help you to not miss issues, and that will help you to sound coherent in front of the jury. And I think I've got maybe a minute or two, if anybody has any more questions.
Are you gonna be here for the panel too?
And I'll be for the panel as well.
Questions on this issue? Okay, thank you, Scott.
All right, everybody.
We'll take 5 minutes and we'll get our panel put together, stretch.